a lot of times when we meet people and we'll ask if they have an estate plan, they'll say, well, we had wills drafted up quite a while ago, but maybe they need updated, or we have wills. Is that enough? Is that enough of an estate plan to just have a will?
For most people, it's not, because a will is just simply a letter to the probate court. If you have a will and that's all you have, you're going through probate. Another thing we didn't mention is a lot of times people figure that, you know, owning things joint tenants with rights of survivorship is going to, take care of things. Well, that'll take care of you and your spouse. If the first one of you dies, the second one gets it. That's rights of survivorship. But eventually that person's going to die too. And then if they don't have a beneficiaries named and have a trust and whatnot, that's going to go through probate. If they have a will, it's still going to go through probate. Remember, a will is just a letter to the probate court. So it doesn't avoid probate.
You're making probate sound kind of bad. What's the matter with probate?
Well, number one, it's a public process. It's in court. It's public. All the information, all the documents are available that anybody can see. It costs money because and most of the money is not the court costs, it's the lawyer costs. And it's estimated that the cost ranges from between 3 to 10% of the estate. Well, if you have things like IRAs that have beneficiaries on them, and they're not going through probate, but I bet nobody listening to this podcast named an unknown law firm as a 3% beneficiary of their IRA. Well, we don't want a known or unknown law firm to be the beneficiary of any of your money. And that's how we help people manage their wealth, is we help them to avoid unnecessarily paying to go through the probate process when, like I said, it's unnecessary. It's time consuming. Probate is. It takes 6 to 24 months, depending on different things. And like I said, it's public. So
do you mean if you have something that goes through probate, your beneficiary doesn't get that asset for up to maybe even 2 years?
Right. Because it's until it gets through the probate process, they don't get it. And the way that things end up in probate, if you think about it, is a dead person's name is on the title of something. Okay, think about it. I have a car. I have a truck out in the parking lot. And let's say it's just in my name, Bob Benny. And Bob Benny dies. Well, your mom, Angela, my wife, she can't go and say, well, this is my husband's car, and so I want to sell it. It's frozen. It has to go through the probate process. And the probate court process is the legal process of determining who gets the truck. Well, maybe if I had a will that said if I die, everything goes to your mom, Angela, then yeah, she gets it eventually, and after having to pay to go through the probate process. And so that's the thing. It depends on how things are titled on whether they go through the probate process or not, with or without a will.
So what kind of estate plan can you have that would avoid that process?
Well, the most efficient for most people, and for most of the people that we help, is a thing called a revocable living trust. And the revocable living trust has tons of advantages versus not having one or having a will. What are the advantages of it, Jess?
Well, the biggest advantage is that it completely can avoid the probate process if it's done correctly and funded correctly, which we'll talk about later. Another advantage is that it keeps your family business private. The only people that get to know what's in your trust document are you, because you're going to be the trustees, and the successor trustee, whoever it is that you name to take care of all of your assets after you pass away. It's not a public document that everybody gets to see and know who you gave what to, that kind of thing. Keeps everything in the family. It keeps your assets in your control. As long as you are living, you are both the controller, the manager
Right.
of the trust and the beneficiary of the trust. Not all trusts are like that, by the way, but a revocable living trust is like that. You maintain control of all of it the entire time that you're living. And then it saves your family the time and money that the probate process costs them. And lastly, it simplifies things for your family when you pass away so that they don't have to hire attorneys. They don't have to go through courts. They don't have to take all this time and go through all of this work just to get what you wanted to leave them. Instead, everything is much more streamlined and easily taken care of.
Right.